A very good evening to you, Doctor. We thank you very much for your time this evening. Essentially, what is your view on the report in general?
Thanks so much for this opportunity. I think the report is a very good step forward. I want to note, though, for all the viewers' benefit, of course, the panel was constituted to represent diverse skills and sectors. We had lawyers, we had farmers, we had representatives of the commercial farming sector, we had agricultural economists and academics. So we had a broad spectrum of views, and of course we disagreed on some issues, as the President of AgriSA has explained. At the same time, my view is that the report takes us forward in terms of clarifying a way to deal with expropriation without compensation in a manner that is law-bound and fair. There clearly is an overriding demand from society that there must be decisive action on land reform, including expropriation, to take forward the process, and yet it's clear that expropriation by itself is not going to resolve all the problems of land reform. So I would emphasize that while we disagreed on some issues, including whether or not a constitutional amendment is actually needed, we recognize that already Parliament has voted that there should be constitutional amendment, and in fact this week reconstituted a committee that's charged with looking at the wording of a new clause within Section 25, which deals with property. So we have suggested potential wording, but also importantly, what we've proposed is that there needs to be a compensation policy to set out when compensation should be paid for property that's expropriated and when not. And importantly, when there should be a degree of compensation, but not at market price. And so we think that there is a need to clarify the law on this. The expropriation bill has been published, and that needs to go through Parliament. We have suggested that there are 10 categories or situations where expropriation without compensation may be merited. But equally, there are many situations, for instance, where there is a going concern, land is being well used, a family has invested their capital in the land, where expropriation should attract compensation. So we have provided some practical ways forward, but what happens now depends very much on Parliament.
Essentially, how does that differ from the provisions that already allow for land to be expropriated without compensation? And another word that stood out for me in this report was equitable. How is it defined to be equitable? What are the terms and the conditions or the criteria to be able to table that?
At present, the property clause sets out that there should be just and equitable compensation. The debate within our panel was, could it be just and equitable to pay nothing? And the view of the panel is that the presumption of the Constitution is that there should be compensation, and for this reason we proposed a minor clarificatory amendment that would enable the state to expropriate without paying compensation where it is just and equitable. And by equitable we mean taking into account the interests of all parties concerned, including the owner of the property, and also taking into account the purpose for which the property is to be expropriated. I would emphasize, though, that it's important not to focus only on the power of the state to expropriate, but equally on the rights of citizens to gain access to land. So in addition to addressing the expropriation issue, our panel also proposed that there should be a new framework law to set out what constitutes equitable access to land. The right of citizens to equitable access is already a constitutional right, but there's been no law since the Constitution was adopted in 1996 to give effect to this. Our view is that equitable access means that the needs of those who are in greatest and most urgent need should take priority. And this means that citizens should be able to approach the state and to explain their situation, that they are landless and homeless, and they should be able to seek remedy, and the state should be obliged to respond to them. I would emphasize that there are many other elements to the report, including a call for an end to farm evictions and for the state to beef up its implementation of the laws that that protect farm dwellers, and also, importantly, there is a whole section that addresses the rights of people living in the communal areas, the former Bantustans, which actually constitute around 30% of our population. And there we have failed over the past 25 years to establish clear rights in law and in practice for people who are the traditional occupiers and de facto owners of that land. So we have made significant recommendations, including that before any laws such as the Traditional and Khoisan Leadership Bill are signed into law, there must be meaningful engagement with communities who have raised concerns that these laws could actually undermine their property rights.
Speaking of that, as we turn the focus then to the traditional sector, of course there have been recommendations that the Ingonyama Trust Act be repealed or disbanded. Can you take us through some of the conclusions, or rather some of the recommendations around that debate?
Thank you. Yes. First, I want to mention that in the course of our work as the panel, we reviewed research. We also held round tables with people in various parts of the country, civil society organizations, rural residents, urban residents, and some of our recommendations on the issues around communal land were influenced by meetings that were held with residents from the communal areas who raised extremely serious concerns around tenure insecurity, people being dispossessed of land in the communal areas, facing commercial investments, and land being transacted over their heads. And so these were very serious issues that we addressed. What we recommended was that either the Ingonyama Trust Act should be repealed in its entirety, or the act should be reviewed and the whole process, the vesting of land should be devolved from the Ingonyama Trust to the people who already occupy that land, and that governance should happen at a local level through the traditional councils. The important distinction here is that people who occupy that land are the de facto owners, and traditional institutions play an important governance function, but it's important that the rights of the residents, including to free, prior and informed consent on any transacting of their land, must be recognized in law.
Now, just let's speak a bit more about the report also making those specific recommendations around women in particular, as well as farm dwellers in the case of the Ingonyama Trust, and of course some of the challenges that we've seen pertaining to those two. Okay, well, particularly one of the findings of the report is that if we look at what has happened with land reform over the past 2 decades or so, in fact, the focus of the program has tended to move towards establishing commercial farmers, and particularly men. We found that women constitute a small minority of beneficiaries of the land reform program, and so we make a specific recommendation that women should constitute at least 50% of the beneficiaries of land reform, and of the available resources from the state, at least half of that should be going to women. We also make recommendations for a more equitable distribution of money and land across the 4 categories that have been identified in policy. That is the poor, farm dwellers and subsistence farmers on the one hand, smallholder farmers who are commercially farming for local markets, medium-scale farmers, and then established large-scale farmers. And what we recommend is that the first 3 categories, the small and subsistence farmers, the commercial small farmers, and the medium farmers should each get 1/3 of the national budget, and only 10% be reserved for the more established large-scale farmers. And we feel this is important because the more established farmers are better able to access commercial lending and to use their own capital. What's important is to refocus the land reform on the needs of people who cannot access finance through commercial means. Just briefly, can you just talk to us or take us through the inclusion now of the Khoisan in particular, and how these recommendations are going to be affecting them?
The issue of the Khoisan demands for land restitution were taken very seriously. Khoisan people were dispossessed at scale of their land and their territory and heritage well before the 1913 Natives Land Act. And so when the constitutional negotiations agreed that 1913 should be the cutoff date for land claims, this excluded those large swathes of land from which Khoisan people had been dispossessed. And so their lobby has been to amend the constitution and to remove that cutoff date of 1913. We looked into this, and there have been many debates about the merits of turning back the clock prior to 1913. There are both political, legal, and practical challenges in doing so. We did not recommend that there be change to the Constitution to change the 1913 cutoff date. However, we pointed out that the minister has ministerial discretion and authority to address the claims of the Khoisan people through her discretionary power. So we have called on the minister to engage with the Khoisan people to identify land and territory that is under claim and to expedite the settlement of those claims. Importantly, this shouldn't require proving historical rights to particular parcels of land. The minister has the power to acquire land and transfer it, including through the redistribution process. So we hope that our recommendations will provide some way forward for the many Khoisan people who rightfully have argued that they've been left out of the land reform process.
And on that, let's talk about the administrative aspect that we've seen in this land reform process and the many changes that we're going to see going forward and that will be put in place.
So far, land reform has had three legs or pillars to it: land restitution, land redistribution, and land tenure reform. What we have proposed is that what's been missing is the issue of land administration. Land administration is crucial because it's the question of how do people's rights get recorded, registered, and administered. Now, what we found is that around 60% of South Africans have no formal or documented rights to the land that they occupy and use. So we have a deeds registry system that works well for people who are private owners of property, but people who live in the communal areas, on commercial farms, in informal settlements, and elsewhere have no documented rights. What we're proposing is a land records bill that will allow every South African to document and record the house or property on which they are resident, and that there should be legal recognition of the particular rights that those people have to that property. This will require the state investing in land administration, which has been sorely undercapacitated over the past decade or more. So we feel that land administration is actually a crucial step forward in recognizing that all South Africans have property rights, regardless of whether they're owners or not. They have rights to the land that they occupy and use, and this has to be recognized, and there has to be institutional muscle put behind documenting and defending those rights.
So much to talk about. Unfortunately, we're going to have to leave it there. We thank you very much for your time, Professor Ruth Hall from the University of the Western Cape Institute for Poverty, Land and Agrarian Studies. Just more on that land reform report that was released today, as well as more on the Ingonyama Trust and some of the recommendations and the debates around the Ingonyama Trust as it stands. We're going to take a short break.